Hello, everyone. Welcome to the Virtual Hammer Museum, coming to you live from Los Angeles. I'm Claudia Bester, and I'm the Director of Hammer Public Programs, and I'm very pleased to welcome you to today's Hammer Forum on the recent Supreme Court decisions on whether or not the President of the United States can be compelled to release his tax returns. Before we get started, I have a few notes for the audience. This program is being conducted via Zoom webinar, and in a Zoom webinar, we cannot see you in the audience and we can't hear you. We can just see your names and anything you type into the chat box and in the Q&A box. We'd love for you to all introduce yourselves in the chat box and tell us where you're tuning in from. And the chat is also an area where you in the audience can all talk with each other. And the Q&A box is where you type in questions you have for the panelists. Please note this program is being recorded and will be available later on the Hammer website. And if you'd like to receive reminder emails about our upcoming events, please sign up for our newsletter on the Hammer website. And you can also find recordings of most of our past public programs on our website as well. So on to today's program. The Hammer Forum is a monthly series of public discussions about current social and political issues and is made possible with support from the Rosenblum family. So just 2 weeks ago, on July 9th, the Supreme Court decided on 2 cases pertaining to whether or not President Trump can prevent his accountants or lenders from turning over his financial records. At issue here is ultimately whether or not the President of the United States is above the law. And thus these cases can have a major impact on how we all move forward as a country, even if they don't ultimately affect the specific case of President Trump. We're very lucky and honored to have 2 people who are very close to the topics at hand here with us tonight. Neil Katyal is the former acting Solicitor General of the United States under the Obama administration. During his tenure there, he argued several major Supreme Court cases, including a variety of issues such as his defense of the constitutionality of the Voting Rights Act of 1965, his defense of former Attorney General John Ashcroft for alleged abuses in the War on Terror, a unanimous victory against 8 states who sued the nation's leading power plants for contributing to global warming, and a variety of other matters. As acting Solicitor General, he was responsible for representing the federal government of the United States on all appellate matters before the U.S. Supreme Court and the Court of Appeals throughout the nation. He served as counsel of record hundreds of times in the U.S. Supreme Court. He was also the only head of the Solicitor General's office to argue a case in the U.S. Court of Appeals for the Federal Circuit on the important question of whether certain aspects of the human genome were patentable. Professor Katyal has extensive experience in matters of patent law, constitutional, technology, securities, criminal, employment, and tribal law. He has orally argued 41 cases before the Supreme Court of the United States, with 39 of them in this last decade. And at the age of 49, he's also argued more Supreme Courts in US history than any minority attorney, recently breaking the record held by Thurgood Marshall. After graduating from Yale Law School, Neil clerked for the Honorable Guido Calabresi of the US Court of Appeals for the Second Circuit, as well as for Justice Stephen Breyer of the US Supreme Court. He also served in the Deputy Attorney General's office at the Justice Department as National Security Advisor and as Special Assistant to the Deputy Attorney General in 1998 and 1999. Katyal has published dozens of scholarly journals in law journals scholarly articles in law journals, as well as many op-ed articles in publications such as the New York Times and the Washington Post, and has testified numerous times before various committees of both the U.S. House of Representatives and the U.S. Senate. He now works with the law firm Hogan Lovells and continues to teach law at Georgetown Law School, where he's been a professor for over 20 years. Ariane DeVogue serves as a reporter for CNN, covering the Supreme Court and legal issues, chronicling everything from breaking news about major rulings to the evolving politics of personality among the justices. She works closely with CNN's justice team and guides network-wide reporting on Supreme Court cases and other legal developments. Since joining CNN in 2015, DeVogue has covered the sudden death of Justice Antonin Scalia and the nominations of Judges Merrick Garland, Neil Gorsuch, and Brett Kavanaugh to the Supreme Court. She's also covered groundbreaking Supreme Court decisions on gay marriage, healthcare, religious freedom, and abortion. During and after the 2016 election cycle, she has followed voting rights challenges across the country and has explored legal issues surrounding the president's executive orders. Prior to joining CNN, DeVogue covered the court for ABC News. As an investigative producer for ABC, she also worked on stories concerning terrorism, the aftermath of September 11th, the presidential impeachment proceedings, campaign finance regulations, and legal challenges during national elections. Our moderator tonight is Loyola Law School professor Jessica Levinson. Levinson studies the law of the political process, including election law and governance issues. Her work focuses on ethics, political corruption, voting rights, campaign finance, ballot initiatives, redistricting, term limits, and state budgets. She regularly appeals as a legal and political expert on television and radio and in print. She's the host of the new podcast, Passing Judgment, and has a weekly legal segment on NPR member station KCRW here in Los Angeles. She's also an op-ed contributor for NBC.com and the associate director of Loyola's Journalist Law School. Professor Levinson served as the president of the Los Angeles Ethics Commission until 2018. She's also the founding director of Loyola Law School's Public Service Institute, which is dedicated to creating the next generation of leaders in government service. So hello, all of you. Welcome, Neil Katyal, Ariane DeVogue, and Jessica Levinson. There you are. Jessica, you're muted.
There we go. I think I was muted by the hammer. And so I did threaten to do an interpretive dance if people couldn't hear me. And I'm just wondering, Hammer staff, is this exactly, was this the moment that you were trying to make that happen? So I really am absolutely thrilled that Ariane and Neil could join us tonight. These are two of the nation's experts on the Supreme Court, and these are obviously two of the most anticipated cases that we're talking about. So I have three really quick slides. I'll ask for those to be brought up. And the first slide is just what we're talking about, Trump's finances, not just his tax returns, but his finances and issues of presidential oversight, congressional oversight, and presidential immunity. So if we could bring up the next slide, there's actually two different cases, and we're going to talk about both of them. The first deals with a state criminal subpoena and whether or not it can be served on a sitting president's accountant for his personal financial information. It brings up issues like, is a sitting president immune not just from prosecution, not just from indictment, but also from investigation? And it brings up issues of the supremacy clause of the Constitution. So I'm just previewing things that we're going to talk about. The next slide, thank you, Hammer staff, you're anticipating my every move. The Mazars case, and this deals with whether or not Congress can subpoena the president's personal financial information. Again, we're not talking about official documents here, official White House documents. We're talking about the president's personal financial information. Whether or not Congress can ask for this information or if it violates the separation of powers, and what standard Congress should have to adhere to if it's different because we're talking about a sitting president as opposed to somebody else. So with that, let's bring down the slides, please. And Neil, I want to start with you briefly. Ariane is going to, as she said, and I love this expression, set the table for us for the cases. But first I want to ask you, let's start with the Vance case, and then later we'll move on to Mazars. And with respect to the Vance case, the New York case, Ariane's going to talk about the case, but could you tell us a little bit about the political background? Why are we interested in Trump's financial information, and specifically, was some of this actually started as a result of Michael Cohen's testimony in Congress?
Okay, so first of all, it's a real pleasure to be here at Hammer and with these two. Jessica has written some great work on campaign finance that I'm a fan of, and Ariane's one of the very best Supreme Court reporters and people who cover the court. So it's a real privilege to be with both of them and with all of you tonight. With respect to your question, Jessica, so yeah, I don't think it's really political. I do think it's legal. So basically, President Trump's former lawyer, Michael Cohen, evidently has told the Manhattan prosecutor, the local prosecutor, not a federal prosecutor, but he's also told this to the federal prosecutors. That's why Trump is named individual number one in some of those U.S. attorney documents from the Southern District of New York. But here, This case, Trump versus Vance, is about what this local prosecutor is doing. Basically, Michael Cohen said that his former client, Donald Trump, had expensed the $130,000 in payments he made to Stormy Daniels. And it doesn't take a rocket scientist to know that if you're expensing payments to a porn star to cover up an affair, that's just not a business expense, even under whatever business the Trump organization might have been running. So the DA wanted to look into that and say, hey, are you getting a $130,000 tax break? And so they issued what's called a subpoena, which is a legal request for records. The grand jury issued that, and not to Trump himself, but to Trump's accountants. And then the president said, "Oh no, you can't do that. You can't even investigate me." And that's how the case began. So it begins with an allegation that a sitting president committed a crime. And now the prosecutors want to go and get that information. And what the prosecutors are basically saying is, look, if it's you or me, if it's Jessica or Ariana or me, and we're accused of expensing $130,000 in that way, of course the prosecutor is going to look into it. Of course they're going to subpoena. Of course they're going to get all this information. Why are you different just because you're the president?
So I have to say, even a year ago, I did not envision myself in a panel asking the former acting Solicitor General a question about expensing payments to porn stars by the now President of the United States. So with that terrible transition, Ariane, we're going to have dinner here tonight. You said you're going to set the table. We have a great pre-setup. Tell us a little bit more. We know why the Vance case started. Tell us a little bit more about once we get to the Supreme Court. What are the big issues here? How did it come to the court? What are the issues we should know about?
Okay, and I think I can do it pretty quickly, but first let me say thank you to Hammer, and also thank you, Jessica. I call you in a panic more than once when you're helping me with things. And Neil, who I've known for years. If any of you out there are wanting to be a lawyer, he is one of the best appellate lawyers out there. Get your hands on audio, listen to him argue, because it is a real pleasure. He's an extraordinary advocate. So now, setting the table. Keep in mind, this all starts, right, with the fact that Trump's critics, long before he even became president, wanted to get a better glimpse at his financial records, right? Not many presidents have had such vast financial holdings, and most recent presidents have turned over tax returns. He's declined to do so. So as Neil said, this investigation started with the Manhattan DA, Cy Vance, and he was looking into, among other things, hush money payments, right? And he did send these subpoenas. And this is what's key. He sent them to, not directly to Trump's longtime accounting firm. These documents asked for the tax returns, not in the other cases, financial documents, the tax returns. And keep in mind, these are not official sort of White House working documents. That's what he asked for. Trump hired personal lawyers and raced to court. And he came out with this very broad, sweeping defense. And he said he has, the president has absolute temporary immunity from criminal proceedings, particularly this one because it was brought by a state prosecutor. And let me read you, just to give you a hint of what some of his lawyers said in court. Our constitutional system does not, and indeed cannot, abide a rule that would allow the nation's choice for president to be hobbled by the whims of local officials serving local constituencies with local priorities. Now, the Department of Justice sided with Trump on much more narrow grounds, right? Saying, look, if you want these documents, you have to reach a higher bar because this is the president. And for his part, Vance said, look, I'm looking at, this is a third-party subpoena for these non-official documents. I want it to be able to go through. The lower courts ruled against Trump, and the appeals court ruling there was really interesting because it was modest. And that judge is one of the smarter judges, and he was almost laying out sort of a roadmap for the Supreme Court, saying, look, you don't even have to get to the fact that we're talking about presidential immunity. All you're looking at is a third-party subpoena for non-official documents. but the case goes to the Supreme Court. And at oral arguments, which were telephonic, I think most people left saying that most of the justices were not buying President Trump's major argument, right, with this broad sweep of immunity. But the question for me and for others was, what would they think about the Department of Justice's argument, right, about the president being different? So then we get to the Supreme Court, we get the opinion. As you said, it was 7-2. That's important. Chief Justice John Roberts and the liberals, and very importantly, Neil Gorsuch and Brett Kavanaugh, who are Trump's nominees, they write separately, but they agree here with John Roberts. This is the key. All the justices on the Supreme Court rejected these broad claims of immunity from the president. It was his major argument, and all of them rejected that absolute immunity. But they also, all the justices thought this should go back to the lower courts. And I think Neil and I might disagree in a minute about that part of it, but it's worth noting. Roberts said, he said, we hold that the president is neither absolutely immune from state criminal subpoenas seeking his private papers, nor entitled to a heightened standard of need. So, right, the president loses there and the DOJ loses. He goes through, and it's a great opinion. I was telling my kids today, I want them to read it because it's got so much history. He starts with Aaron Burr in 1807. He walks through the Nixon cases, the Clinton cases, and he says, he starts out, the public has the right to every man's evidence, right? And he says, look, a properly tailored subpoena won't distract the president, won't stigmatize him, won't harass him under the right circumstances. He notes that this information would be guarded by grand jury secrecy rules. They wouldn't be out. But here's what's key. He did not do what the lower court did. The lower court said that these subpoenas could go out. And instead, he said, he sent it back for more proceedings. He said, there's some things the president can do. You could look into a specific subpoena to see if it's made in bad faith or overly broad. But what's key is this was a 7-2 opinion, right? He did not, John Roberts did not want this to be 5-4. He wanted to be 7-2, and he got Gorsuch and Kavanaugh in here. And Gorsuch and Kavanaugh said, look, we want this to go back to the lower court on these remaining issues. So this is a big case. It's a big marker on executive power. It was a firm rejection. But if you're President Trump, and if you were worried that these subpoenas might come out before the election, this was a little bit of a win, right? Because that didn't happen. Now it could get sped up, but you know, the system takes some time. So that's where we are. Now the case has already gone back to the lower court. And I was just reading today, Trump's lawyers are already back in court. And in their papers, citing Gorsuch and Kavanaugh, they say, we're back. We have more arguments to make. We want to make them. So that's where we are right now. Does that set the table for you? Is that
you absolutely did. You polished the silverware. There's no wrinkles in the napkins. That was perfect. Neil, I have about 15 follow-up questions, but let's start with one of them, which is the split in the court. And how important do you think it is that it wasn't a 5-4 decision? You clerked on the Supreme Court. You've argued before the Supreme Court. How important is it just psychologically that you get 7-2? And how significant is it that you get President Trump's 2 appointees?
Yeah, I think it's important both for what it says about the court and what it says about Trump. So what it says about the court is, in an era when so many people are dispirited about our institutions and they think everyone's just kind of got bad motives, you've got the court here saying, that's not how we play. We abide by the rule of law. And, you know, the essence of the rule of law is literally Lady Justice being blindfolded, blind to which party is before her. And I think, you know, that the court here did really take strides to move toward or to retain that conception of the law. It's the same conception of the law that you saw in the Nixon tapes case in 1974, when President Nixon tried to quash a subpoena. That one was for official documents, and Marianne's right to make that distinction. But even for those official documents, those were the Oval Office tapes, the Supreme Court unanimously said, hey, you got to turn that over, Nixon. And that included 3 appointees of Richard Nixon's. And here you've got these 2, Kavanaugh and Gorsuch, saying, Trump, we're not buying your argument. And so I do think that's really a pretty profound statement about the rule of law. And I think the court should be really commended for that. Now, what does it say about Trump's arguments? Well, I mean, look, I had the privilege of representing the president and the Supreme Court. And the one thing I'd say is if you have that privilege, it's really hard to lose your case in the Supreme Court. There's so much deference given to you as the president. Like, you really got to try to lose. As I say, it's like failing a class at Yale. You got to really try to do it. And, here Trump managed to do it with outlandish arguments. They were just, so silly. Those arguments weren't rejected, as Ariane says, 7-2. They were rejected 9-0. Nobody bought them. And so, 2 justices by a little bit of the Solicitor General's reading that, you've got to have a heightened need for these documents and so on. But it was a pretty thorough rebuking of the president and his legal arguments. And so what you're left with is a holding that says the president is not above the law. Now, it also says he's not below it either. And so like an ordinary citizen, the court says, you have the right to, try and quash a grand jury subpoena if it's vexatious or something like that. You're an ordinary citizen. You don't get any special perks because you're the president. Ariane characterizes that as a win or something of a win for the president. I guess here's where I would disagree. I think that it was impossible for the court to say anything else because after all, the Manhattan DA had conceded exactly that in the briefs and in the oral argument and said, look, this is going to have to go back because we're saying the president's like an ordinary citizen, and now the president should be able to test that and say, hey, I'm an ordinary citizen, this is vexatious. But boy, it goes back under the Cy Vance's, the Manhattan DA's standard that he wanted, which is almost impossible it is impossible, I'd say, for the president to win. And, he can file all the briefs he wants and hire all the fancy lawyers he wants. But the truth of the matter is there's no way, shape, or form in which an ordinary citizen could ever be able to quash the subpoena. The only way he could is by saying, I'm the president, you can't investigate me, or something like that, or heightened need, or some of that. All of that has been thrown out. And so the question left is this going to happen before the election or after the election? Well, as I said that day when the decision came out, the judge in this case, Judge Moraro, has moved incredibly quickly in the past proceedings and has done so again here. The parties set a date for briefs of August 14th for both sides' briefs to come in. The judge had a hearing. He's like, I actually kind of think it should come earlier. I'm worried about the statute of limitations, which is something the prosecutor had talked about. But he said, all right, I'm going to go with August 14th. But I think it's moving very fast. And I think the Second Circuit, right afterwards, the Court of Appeals can move quickly. And I don't see this being granted by the Supreme Court at all. I don't think the president has a legal leg to stand on. So could this happen before the election? Possibly. Either way, it is very, very bad news for Trump. He's been fighting tooth and nail with ridiculous arguments to try and hide this stuff from the American people. It's coming out. Whether it comes out in January or October, remains to be determined.
That was one interesting thing, Jessica, that I thought was that when we looked at this case, you're looking at it politically and you're looking at it legally. And I think legally, the Supreme Court set a real marker here. But I do think that politically, and this is where I differ a little bit with Neil, but not really a lot, is that that if you were doing this and if you were making these arguments in order just to get up until the election and not have these subpoenas come out, there's a possibility, and I know things move quickly, but there's a possibility that they won't. And that's why I think the day of the argument, everybody was or the day of the opinion, we were all looking at it, and you had to put your legal hat on, and then you had to put your political hat on, and you see that a lot with Trump, right? You see sort of how his activities in the court and sort of the legal angle and the political angle.
Yeah, I mean, there will be books written about the law of politics and the politics of law after the Trump administration, for sure. And
If we're
Neil,
allowed to write books, I don't know. We'll see.
for those people for whom the First Amendment still applies, and we can do a whole separate forum on non-disclosure agreements. Neil, I want to come back to you for what's going to feel like an obvious question. But one of the things that I try and talk to my students about is don't just think about whether or not you want President Trump to succeed or President Trump to fail, but think about whether you want whoever is sitting in the Oval Office to be able to succeed on this particular claim. So, in the most general sense, what I see President Trump's claim to be is, I'm the inhabitant of the Oval Office. You don't get to investigate me. I know the subpoena didn't come to me. I know the subpoena is going to somebody else, but I'm immune from state investigation. What would it have meant if President Trump had won? I just want to make it clear for the audience. What would a contrary ruling have meant?
It would have meant basically we're in the realm of King George III. I mean, it would be someone is literally above the law. Like someone like me, even when it's Donald Trump, I think justice is blind. So I think the same rules apply to the president, even if we have someone who's, in my judgment, a constitutional aberration. But, I don't think that a sitting president, for example, can be tried. I think that would be dangerous. I worry about South Carolina in 1863 trying to try Abraham Lincoln or something like that and undo the nation's will, even though they're only one state. But no reasonable constitutional scholar that I am aware of says that a president can't be investigated. I think I come out and say a sitting president could even be indicted, but you just can't formally bring the trial because you're worried about statute of limitations and things like that, so you can indict. But I think there's no question that a sitting president has to be investigated. Otherwise, you literally are putting someone way above the law, and that can't possibly be the right way of thinking about it. And impeachment works sometimes, but obviously in an era of party politics, or if you have the president and the House controlled by the same political party, you're never going to have impeachment, and then we'll literally have an unchecked executive. That's a silly view of the law.
And there was this, Jessica, one thing
yes,
that was
please.
really interesting is in the lower court, and we were listening to the audio, before it hit the Supreme Court, President Trump's lawyer said to court, was asked by one of the judges, well, what happened if a president were to shoot somebody on Fifth Avenue? And the lawyer came back and said, well, no, can't be investigated. That was very stark. But it also makes you wonder, as we think about this case, Trump's role and then the president's role, how many other presidents would think to come to court with such a broad assertion there? And not only, again, did the president, Trump's his arguments get rejected, but the Department of Justice's did too. The court did not buy into that heightened standard that they wanted. So I think that's interesting too.
I think I'm going to start a band after this called Constitutional Aberration in honor of what Neil just said. But so let's talk briefly about that President Trump lost. And because his claim, as you said, was so, in my mind, just unspeakably broad to say, you don't even get to investigate me. But then the Department of Justice, as we talked about, had a slightly different claim, which was just, you're not talking about John Smith. You are talking about somebody whose title begins with the word president. And so we should treat that person differently, maybe not make them completely immune, but treat them differently. Is there any, to both of you, Neil, we could start with you if that's okay. Is there any precedent to back that up? Did the Department of Justice have a point there?
Well, I think that they, if this were 1995, I think that they would have had something of an argument there. The problem was in 1997, the Supreme Court decided the Paula Jones case, in which President Clinton basically made a version of that argument. And the Supreme Court said, no, you're not special because you're the president. You get the same basic rules that everyone else gets. And sure, you're the president, so you're going to be busy. in ways that not everyone else is. And so when depositions have to be taken or something like that, they can be done to accommodate your schedule. But you don't get any special immunity just because you're the president. And I think that just pretty much knocks out this whole heightened standard rationale, which is why I think the Solicitor General had such a difficult time at the oral argument. I mean, I sympathize for him because he was sent in, or maybe he invented this position, I don't know, but it was a silly position to begin with, given the case law. And I was covering the hearing live with my friend George Conway, and both of us, were basically aghast at how bad how terrible the reaction was to both Trump's lawyers' arguments and to the Solicitor General's arguments. But I think that just reflects, it's not anything about their lawyering, it's just, these are really silly arguments, and the court blew through them right away.
So if these are such silly arguments, Perry has a question in the Q&A that's about Vance that I want to get to before Mazars. Ariane, the part of the case was unanimous. Part of the case was 7-2. And Perry says, what were the principal arguments of the dissenters?
Right. So you had, interestingly enough, they were not together on it, right? They wrote separately. Thomas took, they both rejected what Trump had said, his major argument. But I think that they felt like the majority opinion was too lenient, right? And so Thomas talked a lot about originalism. He said he would have vacated the decision that went in favor of, that went against Trump. And he was really worried about harassment of the president. So he didn't particularly like some of the things that Roberts had put out. Alito, on the other hand, he agreed that some subpoenas should be able to go forward. But he said he really bought into what the Department of Justice said, which is a president is different. So that's where and it was interesting to me that they both wrote separately. They weren't together on this, and they both had their own opinions on it. And they did that again in the next case, which will be interesting to look at.
All right, so we're having a progressive dinner. We're moving on to our next table. Ariane, can you talk to us about, these cases were often lumped together, but you have such a fantastically clear way of explaining why they are different. It's actually 3 cases consolidated into one. So can you tell us what were the next big umbrella of cases dealing with congressional subpoenas? What we call it Mazars. Right. Or at least that's how I pronounce it.
Mazars, I learned.
Mazars.
Mazars.
It will not even be the last time tonight that I mispronounce something. What were these cases about? How did they get to the Supreme Court?
All right, so the Vance case that we talked about was about presidential immunity, right? So both of these cases, the Vance case was also about the actual tax returns, whereas the House cases weren't. The House cases were about financial documents. But as one was about presidential immunity, these were about separation of powers, right? That was the heart of it. And there were 3 committees, and they were seeking, again, information from a third party, the accounting firm, as well as the banks. And the committees had different goals, right? The House Oversight was looking into hush money, financial disclosures. The Intelligence Committee was looking into foreign interference with US elections. The Financial Services was taking a very broad look into money laundering and unsafe lending. And so what was key here is the precedent. And the court, the Congress has been able to authorize subpoenas as long as there's what's called a legitimate legislative purpose. That's the key word, if it's a legitimate legislative purpose. So Trump again hires his personal lawyers, and he said, there is no legitimate legislative purpose here. This is a fishing expedition, and it's harassment, and there's separation of powers, and we are not complying here. And again, you see the Department of Justice not totally buying in on Trump's argument there, but again, bringing up this theme that It's the president, it's got to be different, etc. And then you've got the House saying, look, we can tell you all the things that will help with legislation if we can get this. There's lots of legislation. That's exactly what we're doing. The lower court allowed the subpoenas, although one of the courts in that financial services was worried about the breadth of the documents and some privacy concerns, right? At oral arguments, you came in there and one thing was clear right away, that the House lawyer wasn't offering any meaningful limits. And you could see that that annoyed Chief Justice John Roberts right out of the gate. He's like, well, wait, you can do, I mean, really, Roberts was like, give me some limits. And the lawyer was not having a good day in court, and he couldn't articulate limits. And that, I think, really hurt him in this case. Even Justice Kagan at one point, she was concerned about the breadth of one of the subpoenas, thinking that it had gone too far. So here we are, the Supreme Court, again, it's 7-2. But this time, and Roberts writes again, and this time all the liberals plus Gorsuch plus Kavanaugh are with him. And again, Alito dissents and Thomas dissents. And basically the court says, look, Congress can't have these documents for now. And really what the court said, which it didn't say in the other case, is, you know, this is separation of powers. This is different. The presidency is different here. One of the things he said is the House's approach fails to take adequate account of the significant separation of powers issues raised by congressional subpoenas for the president's information. Congressional subpoenas for the president's information unavoidably pits the political branches against one another. And what he said basically is he also rejected Trump's position that nothing could occur. But he lays out a roadmap to go back and again sends this case back to the lower court. And Thomas, he writes, and he basically said he didn't think Congress has the power. And he picked up this argument that one of his former clerks, who now sits in the lower court, Naomi Rao, said was, look, Congress here is doing law enforcement, and that's for impeachment. That's not for this. And Thomas lit up on that. And Alito wanted a much higher bar here. And he said, you know, you've got to describe what exactly is the legislation that you would need or you would do around these documents. So what's next in this case? So in the other case, the Supreme Court agreed to expedite its judgment. Usually it takes about a month. They agreed to get it out there. But just last week, the Supreme Court wouldn't expedite here. And the big problem for Congress here is they're worried that they'll expire before they can get to the bottom of this. So I would, and maybe Neil disagrees with me here, but in this case, I think it's really highly unlikely that the subpoenas go out before the election. And keep in mind, unlike the Vance case, where that information was going to be protected, here it was not going to be. You know, they don't have grand secrecy rules. So that's my table setting on that one.
That was perfect. I did not need an amuse-bouche in the middle. Neil, did the court get it about right? They were worried about separation of powers. They're worried about Congress basically overreaching, about congressional committees that are harassing a president, taking out our, again, you know, kind of same issue, taking out our feelings about this president. Did the court strike an appropriate balance here?
Yeah, I think they did. And it was, again, a really thorough repudiation of Trump. So I think what they tried to do was to say, justice is blind. We're not going to care who Congress is and who the president is. We're just going to try and lay down a rule. And they first reject Trump's view, which is, you can't subpoena me, I'm the president. And, you know, the president's lawyer began his oral argument by saying, this is unprecedented. There's never been a circumstance in which the court has ever enforced a subpoena by Congress against the president, of which the answer, which was given by one of the justices in like 2 seconds, is we've literally never had a president defy a congressional subpoena before. So, of course, there's not precedent on that. So I think, you know, yeah, that got Justice Thomas's vote and Naomi Rao's vote on the lower court. But in the reality-based world of legal decision-making, I thought that was a complete loser. The court saw it as such. Very important for the rule of law that presidents don't just get absolute immunity from congressional subpoenas. On the other side, as Ariane says, that Congress also had a very broad rule, and it became even broader at the oral argument than maybe was clear in the briefs, that basically, there wasn't a limit on when Congress could seek this information. And again, whatever you think about this particular set of requests, which I actually think are probably very important, very legitimate, given the president's, financial dealings. And indeed, we have a new report just in the New York Times in the last day that he's been pressuring our ambassador to the UK to go and get the British Open at his country club in Scotland to generate him some more money for the Trump clubs. That's obviously not something you can do as the president. That's what the Emoluments Clause is all about. And when Elijah Cummings, the late Elijah Cummings, wrote that subpoena, he said, this is what I'm worried about. I'm worried about emoluments violations. I want to understand the president's financial dealings and the like. So look, I think there was a strong, legitimate basis for that subpoena. But the court was confronted with this very broad argument that the House made. And I think they wisely said, no, you've got to actually show a need for this information. Can you get this from other sources? Is your request adequately tailored and no broader than necessary to achieve the objectives that you seek to get? And have you really carefully assessed the burdens on the president when you, issue such a subpoena? I think all of that's totally legitimate and reasonable. And so I think the court reached the right result. And I also agree with Ariane that the result of this decision is that this information will not likely come out before the election, that it's going back to the lower courts to litigate. But again, I think this information is coming out. And it may take a few more months than the Vance case, but I think it will come out.
Neil, you said one thing that I just want to highlight, and it's not directly related. Well, in a way it is to either of the cases, but it's the background of both cases, which is we don't have an enormous amount of precedent on these issues because we've never had a president behave this way. And I don't want to kind of unfairly criticize or throw stones at the president, but I want people to understand again why we're talking about an aberration. And so can we step back for a minute and can you remind us what typically happens? One, do state prosecutors typically subpoena presidential records? Do congressional committees typically subpoena presidential financial records? And if so, then what happens in those cases? Is there a period of something called accommodation instead? Just, remind us of the backdrop here for a moment.
Yeah, normally tax information is already disclosed in the course of an election. President Trump's the first one not to disclose that information. So you never even get to that question because candidates voluntarily do so on their own. He decided to do something that looks fishy and has continued to act in a very fishy way about it. And certainly we've had circumstances in which administrations are requested all sorts of information and some of it's subpoenaed. Those are official documents, some law enforcement operation or whatever, and maybe executive privilege is invoked to try and stop that. And sometimes that goes to courts. And even there, courts are really scared to adjudicate it. They're like, hey, you've got one branch of government, Congress on one side of the courtroom, you've got another branch of government, the president on the other, and we, the third branch, who are we to decide this dispute between these other two branches? And so they generally like to stay out and they try and force accommodations. And so basically the Congress will say, if you don't give us this information, we're not going to fund you or something like that. And I think the result of this decision may be to tell Congress, hey, you got to act more muscularly too. You can't just expect the courts to do your work for you. If you want this information, you've got the budget power in the House. You can use it. You can say, we're not going to fund the Justice Department until this information's out, or fund the Executive Office of the President, or whatever, pick whatever programs you want. But the House still has tools available to it. And notably, those tools don't involve the courts getting in the way. The House also has its own independent subpoena power. They don't have to go through the courts. and they haven't invoked that either. So, there are still mechanisms that haven't been used yet, but I suspect if Trump continues to make these kinds of arguments, they will be used.
Ariane, this brings me to kind of, and I just want you to continue on that thread, the way I wanted to wrap up the Mazars case, which is, was that even close?
You got it.
Okay, even a broken clock. What does this mean for future presidents and future congressional committees? Does it help define those boundaries?
So I see it a little bit more, I see this case a little bit more limiting Congress, I think, in my mind, because I think they said, you got to take, I mean, before they hadn't said this, and now it's on the books that when it's president, you've got to take separation of powers into consideration. And I remember at oral arguments, I was a little concerned when Justice Breyer brought up, the McCarthy hearings. I mean, he was sort of struggling with Congress going too far. And Elena Kagan was worried about, on one side, she's so brilliant at oral arguments. She was saying, the president's not above the law. But she was worried about the breadth of one of the subpoenas. So I do think it was a little bit of Congress, you got to have limits. And I'm interested with Neil because he's so good as an advocate. How would you have gone in there? And when Roberts asked that question, what are the limits here? What's the response?
Well, I think the House had a brilliant lawyer in Doug Letter. I mean, he's really one of the very best lawyers to alive today. So, my suspicion there is what happened, and this happens when you represent the government sometimes, is you're afraid to give up and bind further future Congresses. So if you say, here is the limit, then that gets enshrined into law. And as an advocate, who are you, or even as the Speaker of the House, who are you to bind further future houses and the powers that they might seek? And that's something I always struggled with when I was in the government, which was, I understand the need to articulate a limit. And, at some point it's your duty to, but there's also this countervailing factor on the other side, which is you're binding your successors, and that's an often fraught and dangerous enterprise. So I suspect that's what was going on in the case. It's not as if, he hadn't thought about the limits. I think it was much more that, some reluctance to give it.
And I think what's interesting there too, as a lawyer, they weren't seeing the justices. And I can't speak to that because I haven't argued, but I would think, I would think it's a lot harder. Like, is Ginsburg interested in this? Is Gorsuch, have I satisfied somebody? I think that the telephonic argument I think it was, for me as a journalist, I liked a lot about it. But if I had been an attorney, it's tougher, right? It's almost arguing with blindfolds, and you do get visual cues, I think.
That is such a smart point, Ariane, and it's 100% right. I mean, I feel like a good chunk of my job is going in and watching the justices and observing everything from their body language, literally where they're putting their finger on their face and where the corners of their mouth are. And you're reading the room, and you go, and I watch hundreds of arguments just for that. And these arguments in May, of which both of these cases that we've been talking about were telephonic arguments. There was no video. They couldn't see each other, which is the first time in our lifetimes that that's happened at the Supreme Court. And that may have been part of it, because in the room, it'd be very hard to keep with, oh, there's no limit as an answer. And it might have been a little easier telephonically. Also, the other weird thing is that the questions were done in 3-minute increments, each justice asking him in order of seniority. Whereas when I go in to argue normally at the court, they just throw questions at you, and I get about 60 questions in a half-hour argument. Here, there were far fewer questions, and they were spaced out, and you don't have justices piling on each other. So the no limits answer didn't really get quite the follow-up that it might have otherwise gotten in the ordinary way in which the Supreme Court argues cases.
So this is actually one of the things that I wanted to take a step back from the cases and talk about, because we happen to have two of the nation's experts on the Supreme Court. And I think we actually did a Hammer Forum the night of the telephonic oral arguments, for those of you playing at home who unfortunately I can't see. But Neil, you clerked on the Supreme Court. How much do oral arguments actually matter to the justices?
Well, I mean, I'm not going to say anything about my time at the court clerking, but as someone who basically makes his living arguing cases before the court, I sure hope they matter. I would say that it's certainly the case I've seen people lose cases at the Supreme Court in oral argument because they concede something away that they think sounds innocuous, but it really guts their case. Or they make an outrageous position and, even if their brief looked credible, it dissolves upon inspection, and they don't have a good way to defend it. So certainly that kind of stuff happens. And certainly also the way in which an opinion is written is often shaped by the way in which it's orally argued. But I'd say even before the oral argument, the briefs are really, really important. And, I spend a large amount of time making sure our briefs really try and get at the hard questions and not paper them over, because maybe you can get away with that at some other court, not at the Supreme Court. No chance. They see through. These are 9 incredibly smart people, and they see through all the tricks. So you've got to be really straightforward in your advocacy and say, here's the toughest thing about our case. Here's why we should still win. I think that's a real important piece of Supreme Court advocacy.
And I didn't mean to ask you a charged question. My sense is that it really matters, but I wanted to kind of talk through for the audience because, of course, we don't actually get to sit in on oral arguments. And Arian, we talked about this a little bit, that it was very different to basically be on a conference call with the justices and to hear it live. Do you think this is the beginning of more transparency for the Supreme Court? Or did the flush heard around the world end our hopes of throwing the doors open and having a little technology in those marble halls?
So here's what I think. At the end of the day, I think there was good things and there was bad things. For me, I liked it because it went a little slower and I could keep up with it. And a justice, you could see where a justice went. And Justice Sotomayor, who is famous, and she'll tell you this herself, for interrupting sometimes and changing the course. And I liked that sort of, I could dig into each one. I think what was glorious also was Justice Clarence Thomas, who rarely talks at oral arguments. He liked this format. This format suited him. We heard from Justice Thomas, which I thought was a pleasure. We saw how the other justices reacted to Justice Thomas, not particularly in the financial cases. I think it probably gave Roberts maybe a little too much control, because at times he was really cutting people off, and when he had a lot of lawyers, again, not in this case. So that was interesting. But here's the thing that I think is the most important thing, is that not only were these arguments held over the telephone, but the court released live audio. And I think that is so extraordinary, because I have covered the court for so long and I've seen people sleeping out in their sleeping bags and not many of them getting in, just a few precious seats when you think about it. And I thought that was so extraordinary that people could listen in real time. So for my money, what I think the court might do is, now that they've done this, they don't have to choose between cases. I think that they might continue with that aspect of it, because just as a citizen and as somebody who tries so hard to bring attention to this court after having grown up in Indiana and never hearing enough about it, I think that was really vital.
If I could just say one thing about that, because I agree with what Ariane's saying, but live audio is really kind of skim milk version of what we need. I mean, this is the American people's court. And, I wish everyone could see what I get to see, because it's such a model for respectful disagreement and reasoned deliberation. And in a world in which we're like tearing at each other's throats and insinuating all sorts of bad motives, I think the Supreme Court and the way they conduct themselves is such an important model for us right now. I did a little 1-minute talk at Espen Ideas, which you can see online, about this last week. And I think it should be televised, and I think it should be available for every American to see in real time, not later. And I think that would be a majestic thing for our democracy. And it's nice that we had live audio, but I don't think we should be happy with that. I think this is your court, and we should all be able to see it.
As a journalist, and not as a citizen, but as a journalist, I wasn't such a fan, because suddenly they're like, all right, can you write a couple, what's the headline? And I'm like, I gotta listen, I have to listen to it. So as a journalist, that was a little less, I was kind of like, just let me listen, because I don't want to miss a thing. That was interesting, having to scramble like that a little bit.
Neil, you'll tell me when we're gonna lose you, I think.
Yeah, in about 2 minutes.
Okay, then I can ask you 2 questions and choose your own adventure, if you don't mind. One, is there anything that you want to say to the audience that I didn't ask you? Or 2, is this now truly Chief Justice Roberts' court?
Well, and what to ask me, one thing I think everyone should do who's interested, you can go on oyez.org, oyez.org, and listen to any Supreme Court argument over the last 50 years. It's super interesting. Go listen to, for example, John Roberts' arguments when he was an advocate. They're so good and fun to watch. I studied them all as I started to think about what kind of advocate I'd like to be. This is John Roberts' court. He was in the majority in almost every decision this year. I think it was 60 out of 62 or something like that. He's a justice who cares intensely about the institution of the court and about his legacy in leaving the court stronger than as he found it, which is already very strong. I disagree with him a lot. I argue the travel ban case, the Muslim ban case, which he wrote, 5-4 decision upholding President Trump's travel ban, which I thought was unconscionable and one of the darkest days for the court in our lifetimes. And so I can profoundly disagree with him. But I think that his decisions this term, in particular in the Louisiana abortion case, in the Title VII LGBT rights case, and the like, really do show someone who's doing what I think all of us need to do, which is listen a bit to the other side, learn from the other side, try and find compromise where we can, not compromising the great ideals of the country, but when we can work together, we should. And so I'm hopeful that with under his stewardship, the country is going to get a little bit better than where it is right now.
Yeah, I feel like saying file under low bar in terms of getting better, but I don't want to leave everybody on that note. I will just say to you, we know you have an appearance, so when you need to go, please do so. And if this is the moment, we can thank you. Okay,
thank you all very much. I'll leave you in great hands. Okay.
Thank you, Neil, so much for joining us. I really appreciate it. But we're not done, Arian. And we had a little offline chat, and you said I just want to point out it's 6:03/9:03 for me, and you said, aren't we gonna be done early? And we have 13 pending questions. And I have, as always, did not get through nearly all my questions. Now, is this the portion where we just dance it out, or should we take the questions?
I'm not dancing.
Okay. We have a couple of great questions here. If you don't mind, this one is not about the cases. It's from John. What do you think about term limits for the Supreme Court? Obviously, this has become an increasingly pressing issue. 35 years or age 85, whichever comes first. How would that change the court?
Well, of course, it comes up a lot right now because Justice Ruth Bader Ginsburg at 87 has now announced her 5th bout of cancer, and she is a cult icon. You know, since I've been covering the court with just legions and legions and legions of fans. But there are some critics, liberal critics, who say, you know, you should have stepped down during the Obama administration. And she snapped right back and she said, who would he have been able to put on who was better than I was? I don't think that there's any members. I think she was actually asked about term limits and she pushed back hard on that. And when she gave her statement, I guess Friday, announcing this cancer, she did something she hasn't done before, which is she says it in her speaking engagements, but she said, I will continue to do this job full steam as long as I can, et cetera, et cetera. And if you stop, and I'm speaking out loud because this is a story I'm going to write in the next couple of days, but if you stop and look what this woman did this term while she was suffering her 5th bout of cancer, it's more than I could have done. It really is pretty darn extraordinary. In fact, last week when the Supreme Court issued 2 back-to-back opinions on or orders on the federal death penalty at 3 a.m. One's at 2:37 and one was 3. And I know because the desk called me up and woke me up. She's done a lot, and she wrote an absolute scathing opinion in one of the voting rights cases, which was powerful. She single-handedly led the abortion oral arguments in the Louisiana case. So who makes that decision? I don't know if any of the sitting Supreme Court justices are on board with that one.
Yeah, it's obviously always of concern, and it's of concern when, well, it becomes a new issue every presidential election. And of course, there are some. Wait, do you have a pet that you're going to bring on camera?
That is not me.
Okay.
Mine are locked upstairs, so whoever's dog's barking, it is not mine.
Let's get to a couple of other questions. Did the court have to hear, this is, I think, for the Vance case, this is from Alan, based on when it came in. Did the court have to hear this case? If not, why did they? After Nixon and Clinton, this issue would have seemed to be resolved.
Right. We weren't sure that the court was going to take up this case, but it ended up doing it. And on top of that, you remember when COVID struck and the court had a lot of cases left, it actually only took up about half of the cases. And they said, we're going to take these up and the rest we're going to wait till next term. And interestingly, they took up these 2 cases. They also took up that great case about faithless electors because they wanted to get that issue solved. So it wasn't a for sure thing. I sat waiting to see what they were going to do. And they decided that they wanted to weigh in on this.
A question from Brianna and Claudia. Can Trump be prosecuted for crimes he committed while in office after he leaves office?
So this was, and they said themselves, their argument was it's temporary absolute immunity for a sitting president. So that was what their argument was. And in the lower courts, when they were talking about shooting somebody in 5th Avenue, which, I mean, I was like, am I hearing this right? It was the temporary part of that was while he was in office, talking about distraction, stigma, harassment, etc.
We have 2 questions that came in at about the same time, one from Janet and one from Susan about what we mean by limits. And I apologize, I don't remember where we were in the conversation, what that refers to. So if either one of you ladies, could come back and explain where we were and what you were asking about, we certainly will respond to that. Or Ariane, do you know?
It was limits that we were talking about with the House lawyer? Because
it could have been, what's the limiting principle here? Where, at what point would we have said congressional committees, you went too far. Okay, the answer is yes, you're right. That's what the question was about limits.
It's a really great question, because when John Roberts dealt with these cases, he was looking for a balance, right? What's the balance? And he rejected sort of the polar side, Congress can never investigate. And he was looking for something more reasonable than just out and out, Congress can do whatever it wants. And so that was the problem there. And you heard from Neil, who is so interesting from the advocate's perspective, because, you don't want to give up too much. But clearly in that situation, they wanted some kind of limits, something to say, look, it's not the sky's the limit. It's not that Congress can ask for anything at all times. That's the kind of limiting principle the court's looking for. And Roberts particularly, he wanted to come out with a balance, particularly in that case. And he was pushing back hard, saying maybe Trump went too far, but Congress, you just can't ask for everything. You got to tell us like some kind of limit. Does that make sense?
To me, it does. Thank you. Yes. Let's talk. So let's pick up on that theme a little bit. And I didn't get to ask you this question of, is this now truly the Roberts court? And Peter actually asks a similar question. So I'll read Peter's. Do you have a theory about Chief Justice John Roberts thinking about avoiding the appearance of being a Republican or a Democratic court on these, as well as other high profile issues? So I think the other high profile issues would be, I don't want to put words in his mouth, but where the Chief Justice joined with the liberals, the DACA case, the LGBTQ case, and the abortion rights case.
Well, here's my thinking on it. At the end of the term, obviously, he is in firm control. He was in the majority most of the time. And what I think is really fascinating to think about is that it's the John Roberts special project here. And coming out of it, a couple of people said, oh, is he another David Souter? Is he a justice that's going to end up consistently with the liberal side? And I think that gets John Roberts exactly wrong. I think right now in this climate, he was looking at the institution of the court, and he sees the political branches that have come to a absolute standstill in many ways. And he does not want his court to go down that rabbit hole. We saw it after the Kavanaugh hearings that were so fiery. He gave a speech later saying, we're not Democrats, we're not Republicans, we're justices of the court. When President Trump attacked judges, he came forward and he said, we're not Obama judges, we're not Bush judges. I think that this term you saw more than ever that he cares about the institution of the court. He's an incrementalist, he cares about the institution of the court, but that does not mean that he doesn't have very conservative impulses, because in this term, I actually wasn't surprised by the fact that he joined with the liberals on DACA, because what he was saying there is, President Trump, you can do this, but you didn't do it the right way, like he said in the census case. And I think in the abortion case, which we haven't talked a lot about, he said, just 4 years ago, our court struck down an identical Texas law. We're not going to see a huge swerve just because we have new membership. That's not good for the institution of the court. The LGBT case, where he sided with Gorsuch and the liberals, I haven't wrapped my head around completely. He didn't say anything. I have to think a lot more about that. But then you look at the religious liberty cases he wrote, where he was firmly with the conservatives there, the administrative state cases, and almost really importantly are some of the orders we've seen in voting rights this term. We saw 4 of them. You know that he wrote the Shelby County decision several terms ago that really gutted a key provision of the Voting Rights Act. There, he was with the conservatives and on the death penalty. So I think it's a real mistake to call him anything but a conservative justice. He happens to be the man in the middle. But I think this term really showcased the John Roberts special project here. I'm in charge, and this is the way the court goes. But here's something I was thinking about this morning, is if there is another vacancy, if one were to come up and Trump were to get another justice on the Supreme Court, suddenly that Roberts role would disappear. Right? Because suddenly there might be 5 solid conservatives. And I think that that's so fascinating. This term, he was just absolutely critical, looking toward the future, trying to keep the court out of politics. You saw it with the impeachment, right? He was like, I'm visiting you. I'm a visitor here. I'm not going to get involved in your process. You saw it when he snapped back at Trump. Wow, what a fascinating year to watch Chief Justice John Roberts.
I agree with everything you said. I think that John Roberts is nobody's conservative, but he is everybody's institutionalist. He cares what we think. And, that's why he said, we don't have Trump judges. We don't have Obama judges. We have judges who go to work every day and do their level best to apply the facts of the law. And I think that explains a lot of what we saw this term. And you're right, he loses that role. The role just, the rug is pulled out from under him if there's another appointment and there's a solid 5-4. All of a sudden, he's not arguably he's not the most powerful jurist brokering these big cases. We have a lot of good questions left, but we are over time. So I want to end with going back to the 2 cases we talked about, because I see this question coming up in a couple of the Q&As, which is, will we kind of explain how the public would see this information, both first in the Vance case and then the Mazaris case? Right. How would this get to the public, and what's your guess about, I know we've talked about this a little bit, but what's your guess about when we're going to see this?
All right, well, say in the Vance case, say that this information does get out. It goes to the grand jury. His tax returns go to the grand jury, but there's very strict secrecy laws. So that was not one where suddenly one fine day we'd wake up and see it. So the only way, there are some ways that the information could get out. It could leak, but that would go against the secrecy laws. But if somebody else was indicted, it could be a part of that. But that was always, the Vance case was much more guarded that way as far as seeing it. Whereas Congress, if it had gone differently and they had green-lighted these subpoenas, boy, that was going to come out. And Congress isn't exactly secret. And we would have seen a really big, stunning portrait of his financial picture. So they were 2 different ways. We'll see if the Vance case, like Neil suggests, if those subpoenas go out before, boy, I wouldn't think we'd see that information. And now, really, with Congress, wow, it's not expedited. Congress expires. I think it would be, I'm not sure that we would see it that way. We could maybe get this information differently, but boy, I don't see that happening quickly.
That was my impression after the decisions was, you're going to have to make an assessment of President Trump based on everything we already know, but not based on this information, which
if it had been otherwise, what a bombshell, right? Oh.
Although, query as to what information affects voters these days. And people are so entrenched in their views. I'm not sure that, I don't know, maybe this is terribly pessimistic, but I'm not sure that it would change that many minds. I guess it would depend what's in those financial documents.
Yeah, I can't speak to that so much.
All right, I would like to hold you for another hour, but that was not what was promised. Thank you so much. You set the table, you cleared the table. We ate. You were just absolutely fantastic as always. Thanks to everybody who signed on. This has been a really fun part of the quarantine, is to see so many familiar names, and we hope that we're doing these topics justice, and we thank you for signing on. So, Ariane, I will text you later. You were just phenomenal. Thank you so much. And
again.
Yeah, it was great to see. This is how we're hanging out these days, but okay. I'll take what I can get. And thank you very much to everybody who's Ariane. I know you don't love the chat, but everybody's saying many thanks.
I don't know how to work it, but I'm so happy.
It's so far nobody has. It doesn't look at all like my Twitter feed or my inbox. It's all positive. So thank you. And with that, Hammer staff, will you please play us off? And I'm going to click leave screen, and you can do the same.